The case that is set for argument is case number 29113, Bradley Shillingburg versus Turtle Creek Assets Ltd. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan on reserving time, let me know and I'll keep track of that for you. Let you know as you get close. The arguments are being recorded, so please keep your voice up and stay behind the podium. The judges have read your briefs and we are ready to proceed when you are.
Thank you, Your Honor. Please the court, my name is Michael Fine. I represent the appellant, Bradley Shillingburg, in this matter. I would like to reserve 5 minutes of my time for rebuttal.
Very good, I'll let you know as you get close.
So, Your Honors, the matter before the court today is an extremely simple matter. The appellee, Turtle Creek, is attempting to impose upon Mr. Shillingburg terms of an agreement to which it is not a party, and an agreement which is not assignable. Simple analysis of the four corners of the documented issue of Aaron's mandatory arbitration agreement, together with application of basic rules of contract construction, can lead to but one conclusion, and that is that the agreement is between Mr. Shillingburg on the one hand and Aaron's on the other, and no one else, and it is not assignable. As opposed to what the court wrote on page 2 of its order, and as opposed to what the appellee represented to this court on page 3 of its brief, the title of the document is not Aaron's mandatory arbitration addendum, but as the court can clearly see, it's entitled mandatory agreement.
Now on the very bottom of the page, as I recall looking at the document, it does state addendum and references various contracts by number, does it not?
No, it doesn't, Your Honor.
It doesn't.
What is on the bottom of the page is simply a file footer. It has nothing to do with the text of the agreement. It is not the title of the agreement. It has no impact on the agreement. And if the appellee wants to argue that a footer on the bottom of a document can change the entire content meaning of the document, I would say to the court that the document is inherently deceitful, because no consumer in their looking at such a document is going to think to even look at the footer, much less give it any type of interpretive input. So therefore, to argue that the footer is somehow going to change the meaning of the document is inherently deceitful.
Okay, so I understand that argument, but my question is, doesn't it in fact say addendum at the bottom?
It says copy Ohio C1664 agreement number 4407, and then contracted together it says arbitration addendum volume 1. But no consumer is going to see that. That's not part of the text of the agreement, and it's certainly not part of the title. And as opposed to other agreements that were signed, other documents that were signed as part of this consumer transaction, which are entitled addendum, this agreement is not entitled addendum. It's entitled agreement.
Is there anything in any of the other documents that expressly incorporates the mandatory arbitration provisions?
No, but as I was like to point out, there are terms in other agreements which specifically integrate the terms, integrate the document into the lease purchase agreement. So, for example, the service agreement addendum says specifically within its terms that it is to be read as part of the lease purchase agreement. That language does not appear in the arbitration agreement. Once again, demonstrating that if Aaron's wanted to make the agreement integrated, it certainly knew what type of language to insert into the agreement, and it chose not to do that in this case. And that difference, therefore, by simple rules of construction, have to be understood as intentional. Furthermore, there's no wording in the text of the agreement itself. There's no use of the word addendum or anything similar to that in the text of the agreement itself. And Turtle Creek, the appellee, is not a third-party beneficiary of the agreement. Once again, in the lease purchase agreement, when Aaron's wanted to specify, wanted to make a party a third-party beneficiary, it knew how to do so. It specifically states in the lease purchase agreement that Progressive Leasing is a third-party beneficiary of that agreement. So Aaron's knows how to make a party a third-party beneficiary, and it chose, once again, not to do so with respect to the arbitration agreement. And therefore, that change has to be understood as intentional. And finally, there is no assignments clause in the mandatory agreement. In the lease purchase agreement, again, Aaron's put a assignments clause, evidencing that it knows how to write an assignments clause. So its choice not to put an assignments clause in the lease purchase agreement, in the arbitration agreement, evidences that it didn't want that agreement to be intentional. And that's evident from the entire structure of the transaction documents. Furthermore, the terms of the mandatory arbitration agreement are specifically between we, meaning Aaron's, defined as Aaron's, and only Aaron's, and no other party other than Aaron's, and Mr. Shillingburg. That is extremely limited language. Other cases that are cited in the brief would show that when a party uses specific language like that, defining itself is only between we, a defined party, and another party, that has to be construed constrictly. Aaron's chose that language. These are basic rules of construction. There's only one way to interpret the document. And to the degree that there might be some other way to look at it, that just means that there's a doubt, there's a confusion, there's an uncertainty of terms. And in that case, the rules of construction demand that it be interpreted against Aaron's and against the party that is attempting to stand in the place of Aaron's. And finally, on this issue, I'd like to emphasize that the appellant has no rebuttal. Though this argument about contract construction and interpretation was specifically argued in the case below, and was argued again on appeal. In appellee's brief, appellee does not address this issue at all, because they have no rebuttal to it. There are other issues, there are 3 other issues that we raised in the brief, but this is the issue that I wanted to raise on appeal, specifically because there's no rebuttal, specifically because it's clear, it's obvious, and leaves no room for interpretation. If the court has questions about other aspects of the brief, I'm more than happy to discuss it, to answer questions, but this is the point that I wanted to make in my oral argument.
I do have a question. Counsel, the case you brought in the common pleas court, what does that have to do with the lease purchase agreement?
Nothing. Nothing other than the fact that that Turtle Creek is collecting on a debt which arises under that. But those are completely different issues. So, for example, in the FDCPA setting, when a collector does something wrong, something arises because they're collecting under a debt, those claims are always and consistently by every court that's dealt with the issue, those are not mandatory counterclaims because there's no intrinsic relationship between the affirmative claims and the underlying debt. Therefore, though it's not an issue on appeal, it was raised by appellee in the brief. There can be no issue of estoppel in this case, because the underlying agreement has nothing to do with the claims being brought by Mr. Shillingburg.
And as it relates to the statutory claims inside the complaint, could Aaron's even be a defendant? Because they're not a, I mean, I haven't seen the complaint, but my assumption would be that there are claims about what bad acts happened because a debt collector did them. Am I interpreting the complaint incorrectly?
You're 100% spot on, Your Honor.
Okay.
There is no claim against Aaron's. There's no possible third-party claim. There's no way to plead them in. They have nothing to do with what's going on in this case. This case is simply about the outrageous conduct of Turtle Creek in collecting a $300, $290 some odd dollar disputed debt. Outrageous threats of criminal prosecution, threats of imminent civil lawsuits, defamatory remarks to relatives.
That was
those
really
sorts of
brief,
things.
and you're at 4 minutes and 8 seconds, so.
Unless the court has more questions, I'm.
Okay, so you will have 4 minutes and 4 seconds for the clock.
Thank you, Your Honor.
Good morning. May it please the court, I'm Boyd Gentry on behalf of the appellees. Plaintiff appellant here has narrowed the issue to whether the arbitration agreement is assignable. The argument is made that the word addendum appearing under the signature is just a file footer and therefore should be discarded. The argument is made that there's no specific assignment clause in the arbitration agreement. Those can be dealt with rather easily. First, the presence or non-presence of the word addendum at the top or bottom or middle of the document is irrelevant. Its placement simply does not matter. The word appears, addendum, it's clearly in addendum. And if the document is reviewed in its entirety, it's signed on the same day as the lease purchase agreement that it is addendum to. It has the same contract number appearing under the signature to demonstrate that it's related. This is not a separate document that is executed regarding a separate set of circumstances. This is not something for some other ongoing relationship or unrelated lease or items. This all relates to one transaction, the transaction where plaintiff appellant obtained the cell phone. The question in this case gets to what the idea of is the claim here, the complaint, related to this arbitration agreement? And it is. The claim in this case is dependent entirely on the proof of was there a contract signed? Plaintiff cannot get past the first elements of his case in prosecuting his case unless he demonstrates that he signed an agreement indebting him. He must prove under the Fair Debt Collection Practices Act, under the Consumer Sales Practices Act, that he in fact signed not an arbitration agreement, but an agreement to be indebted. Those are elements to his claims that he's brought in his complaint. So the idea that, no, this case has nothing to do with it is taking a too limited a view of the case. Plaintiff must give these same documents into evidence in an arbitration to demonstrate his case. He cannot succeed without proving his indebtedness. He must first do that. That indebtedness was created by a written contract or reflected in the written contract. That written contract must be viewed as a whole if it's to be viewed as all.
Well, let me give you a hypothetical. conduct that's being alleged is true. And I'm being called. There's 4 people by my name in Ohio. You got the wrong one. I can't sue because I don't have a separate claim because I can't show indebtedness. It wasn't me who bought that phone. It was somebody else by my name. You got the wrong person. I'm having a hard time understanding why why the indebtedness becomes an issue when his claim is about the conduct of Turtle Creek.
Well, that's an excellent hypothetical, and that was not addressed in the briefing. That was not brought up in Collins' brief. But there is case law on that in the federal courts under the Fair Debt Collection Practices Act, which is the main claim here. There's probably almost no case law in the Consumer Sales Practices Act because that's only recently been applied to these since the Jarvis case of a couple of years ago. But under the Fair Debt Collection Practices Act, an innocent third party who is never indebted but receives calls from a robo-dialer or something like that, or receives some offending message, still has the burden to demonstrate that there was an underlying indebtedness and that indebtedness was incurred for personal, family, household purposes. So in that case, an innocent third party who had nothing to do with the debt would not be subject to an arbitration agreement because that person did not agree to that. That person would say, I didn't agree to arbitration, I didn't agree that you could contact me, I didn't agree to anything, you found me out of the blue. So I think those are 2 distinguishing factors. But even in that case, the Southern District of Ohio, I know, has held, I know other courts have held because I've litigated those exact issues. Even the innocent third party must demonstrate the context of it. Now, what we have here is not just an allegation of Turtle Creek or its the affiliate companies that are named as defendants did something wrong, but that this is out of a disputed debt. That is wadded up and intertwined with this, that there is a dispute about whether he really owed this amount, this $300-some. So to extract from the complaint that this has nothing to do with or no relation to the contract issue is a bit of a, I don't know what to call it. It's too much, I think. It does arise out of this contract, and this contract will be a necessary element under Sixth Circuit law under the FDCPA. I'm not aware of appellate law in Ohio addressing it because it doesn't come up very often in Ohio law. The other point I would like to make is that appellant in the briefing admits and acknowledges that Turtle Creek took assignment of the account. And if we look at the bill of sale, the text of it mentioned all rights of Aaron's would be transferred. So there was not some limited transfer of only rights to do something or only obligations to do something. It was a transfer of all rights of Aaron's in that transaction. That would include the right to invoke an arbitration if sued over attempted enforcement of the agreement. This is a case about enforcement of the agreement itself and whether the agreement allowed for Turtle Creek to actually recover anything because he is disputed. That admission is made in the appellant's reply brief on page 4 that Turtle Creek did prove an assignment. And the assignment says all rights. The other point I would like to make here is that the cases cited by the appellant, specifically the Buford and Webb cases.
Well, let's go back to that bill. I just had a question, because you're talking about the bill of sale. I'm assuming it involved all accounts of Aaron's that they purchased.
Not every account of Aaron's, but the bill of sale applied to all accounts that were transferred, yes. It was what they call.
Was there anything to identify this specific account as having been transferred?
Yes, that is Exhibit C to the motion to compel arbitration.
Thank you.
It shows that line. The last point I wanted to make an argument today is that the 2 cases that are first mentioned in the appellant's reply brief seem to be the focus of their rebuttal. And they simply don't hold what the plaintiff is hoping they hold. the Webb versus Midland case from the Northern District of Illinois did not hold that the debt buyer in that case that acquired it, acquired the account, acquired some of the rights and not all of the rights. That case involved whether the debt buyer at all, the assignee, acquired anything. And that court noted and held that the assignee did not submit an unbroken chain of title because there were multiple steps in that chain of title. Here, this is a simple chain of title, Aaron's to Turtle Creek. Very simple, and that's really not disputed in the record. The other case that appellant relies on is the Buford versus Palisades case. In that case, that was on a Rule 12 motion is what the court was considering. The court noted that the assignee in that case, Palisades, did not file a bill of sale in its motion to dismiss. It filed a 12B motion, did not attach a bill of sale, or did not prove a bill of sale. And so the court could not determine what was assigned, if anything. And so on a Rule 12 motion, it denied it. The question of whether an arbitration agreement can be assigned is easy. Yes, it can. And here it was. And we think the evidence and the affidavits and the bill of sale demonstrate that there was a complete assignment, not a limited assignment of any portion. And the arbitration agreement is not a separate, unrelated agreement. It is an addendum to the lease purchase agreement. And the case involves whether any money was owed and what the purpose of the money owed, why was there an indebtedness. All those will come out in the arbitration of the case if the court affirms. If the court were to reverse, we'll go back and have a trial or further proceedings where these issues will be front and center. Was any money owed under the lease purchase agreement? And was Turtle Creek entitled to enforce that? And was it entitled to do the things it did, or did it step over the line? All those will be at issue. If the panel has no more questions, I have none. Thank you.
All right, thank you for your argument. And counsel, you've got your 4 minutes and 4 seconds.
Thank you, Your Honor. I'd like to just emphasize once again in that entire presentation that we just made, once again, opposing counsel, Ellie, has no rebuttal, does not discuss at all any of the issues having to do with contract interpretation that's applicable in this case. Doesn't discuss the fact that it's got a different title, doesn't address the fact that addendum isn't mentioned in the agreement at all, doesn't mention the fact that there's no assignment clause, doesn't mention the fact that it's that as opposed to progressive leasing, it's not mentioned, it's not noted as a third party. None of the distinctions, nothing relevant to this issue is discussed. He ignores it all and simply rushes to decide and says, well, it doesn't matter. It doesn't matter. In terms of this issue of an FDCPA case, opposing counsel is being disingenuous and he's completely wrong. There is absolutely no need to talk about the legitimacy of the underlying debt in this action. Whether or not the underlying debt was owed, wasn't owed, is irrelevant to whether or not it was a violation of the law. And we don't need, and plaintiff does not have to prove anything about the underlying agreement with Aaron's. All they have to prove is that for the FDCPA element, all they have to prove is that the call was for a consumer-related, theoretically consumer-related debt. It doesn't matter if it was owed or doesn't owe. It doesn't matter if there was a contract signed or there wasn't a contract signed. It doesn't matter what the terms of the underlying agreement were. All that matters was that they're calling for a consumer matter, or they think that they're calling for a consumer matter. So in the case of Judge Callahan's hypothetical, it's 100% accurate. It doesn't matter if there was an underlying transaction whatsoever. As long as the collector thinks that that's what they're doing, that's all that's needed to be shown for a violation. Then with regards to the bill of sale, if the contracts are not integrated, the bill of sale only conveys the rights in the lease purchase agreement. That's it. And these agreements are not integrated. And it is not unusual in consumer transactions or business transactions to sign multiple documents, some of which are integrated together and some of them aren't. The fact that they're all part of the same transaction, they were signed the same day, that's irrelevant. You have to look at what was signed and see, are these documents meant to be standalone documents, or they're supposed to be integrated? Some are integrated, they specifically state that they're integrated, and therefore they clearly are integrated. And there's others that aren't integrated. And the fact that the agreements themselves tell you which are integrated and which aren't is not something that can be brushed aside. Well, the footer says everything's supposed to be together, because the person signing the document is going to be bound by understanding what the document means. And because this relates to consumer matter, you have to apply the least sophisticated consumer standard. And in this case, with all of the language of the agreement being distinguished and being clearly a separate agreement with no reference to addendum, no reference to a third party, there's no way that a least sophisticated consumer is going to understand that a document which states that it's specifically between Aaron's and specifically between the consumer related to giving up rights is going to be something broader than that. Thank you.
Very good. Thank you, both counsel, for your presentations today. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail a copy of the court's decision to each of you on the day it's released. And as you probably know, the opinions are also posted on the Supreme Court of Ohio's website. So we want to again thank you for your arguments.